Maintenance means provision of food, clothing and lodging. In legal sense, it refers to the payment to the wife which a husband is under an obligation to pay either during the subsistence of the marriage or upon separation or divorce. Alimony pendithalite, section 36. Where any proceeding for some matrimonial relief is pending before the court, then court can grant some expenses to the wife from husband if it appears to the district court that wife has no independent income sufficient for her support and expenses of the proceedings. On application of the wife, order the husband to pay to her the expenses of the proceeding and such weekly or monthly sum as court seems reasonable during the proceedings. This application shall, as far as possible, be disposed of within 60 days from the date of service of notice on husband. Permanent alimony and maintenance, section 37. Any court exercising jurisdiction in any petition regarding matrimonial reliefs may grant permanent alimony and maintenance. These are the requirements of this provision. On application made to it by wife, at the time of passing any decree or at any subsequent time, court may pass this order, that husband shall secure to the wife for her maintenance and support such gross sum or monthly or periodical payment of money, if necessary, by a charge on the husband's property, for a term not exceeding her life. This order may be altered or cancelled in these cases: change of circumstances of either party, wife has remarried, or she is not leading a chaste life. The court may vary, modify, or rescind any such order at the instance of the husband. Custody of children, section 38. Custody, maintenance, and education of minor children have been attached a paramount importance when the proceeding for any matrimonial relief are initiated and finally decided. Then the court has to make provision for custody, maintenance, and education of minor children. Custody means entrusting the minor in the hands of a person who would look into overall welfare of the minor. Court may pass interim orders during pendency and may make such provisions in the final decree as it may deem just and proper for children. It may be given to father, mother, or even to any other person who may take better care about the necessities of the children. Consequences of civil marriage, section 19 to 21A. The special form of marriage under the Act of 1954 will have the following consequences. Effect of severance from undivided family where any party to the marriage is the member of such family who professes the Hindu, Buddhist, Sikh or Jain religions, section 19. Right and disabilities with regard to the right of succession to any property are not affected by the Act. Severance of family will be deemed by section 19 and right of succession is preserved by section 20. This section not only speaks of right of succession, but it also fastens the married persons with the liabilities which they have to discharge. For example, debts, taxes, and other religious liabilities towards the family. Succession to the property of any person whose marriage is solemnized under this Act and to the property of the issue of such marriage shall be governed by the Indian Succession Act 1925 and not by personal law of the parties. There is one exception to the application of the Indian Succession Act 1925 for succession. Where the parties to the marriage are persons who profess the Hindu, Buddhist, Sikh or Jain religion, then section 19 and 21 are not applicable. Succession to their property shall be in accordance with their personal law.